Now I'd like to introduce our presenter tonight, which is Clint Fischer. Clint is an attorney who specializes in ag business management and transition planning. Clint is also the founder of Braintrust Ag, an online community of ag folks eager to learn, share, and improve their business management and transition knowledge. So thank you, Clint, for being here tonight, and I'll turn it over to you.
Very good. Thank you. First, we'll just get things started off here with some slides, and I will introduce a little bit more about myself. Again, thank you for having me. Tonight, wanted to discuss a little bit about managing the various risks that we encounter as producers, cattle producers, and how to use some common forms of legal entities and some other legal tools to help mitigate and manage some of that risk. And just to start things off, I want to make 2 points. The first one is that I don't know all the answers to your questions, but I do encourage questions. It's always better for these things to be a little bit more discussion focused versus a monologue. And the second is, this is not a picture of me. This is AI ChatGPT's rendition of a Minnesota cattle producer using legal entities to manage risk. So we're looking at some AI knowledge there. And we'll kick things off. So again, my name is Clint Fischer. I'm an attorney in Brookings, South Dakota, home of the Jackrabbits of South Dakota State University. I work for a firm called Ribstein and Hogan Law Firm, and then also have an online peer group called Braintrust Ag, and that started last summer, and it is growing quite a bit. As far as my practice areas, I focus mostly on farm and ranch, business management, and then with a heavy focus on farm transition planning, farm estate planning, and then just general business law. And my background, I grew up in this area of Eastern South Dakota, got a Bachelor's of Science in ag business, and spent 12 years in ag retail, sling and feed, fertilizer, seed, chemical, managing some ag retail locations. Started a handful of businesses. A couple were successful. More than that were not successful, which I actually learned a lot more from, and ended up going to law school later in life, and was one of those old people in law school. So I was the annoying one who asked a lot of questions and made the young kids right out of college despise me a little bit. But so that's a little background about me. And again, I think my contact info will be at the end of this presentation. And we'll kick things off. First, let's talk a little bit about risks. And one of the keys that we look at specifically from a legal perspective on risks is, do we have a plan for the 5 Ds? And we'll go through those. So death. What happens when the majority decision maker? What happens when the majority owner? If it's a sole proprietorship, things like that. What happens when they pass away? Is there a plan in place? Is there some kind of a contingency in order to keep the operation going, in order to maintain profitability for the estate, things like that. So death is a risk that we need to account for. Disability and disease. Well, there's some issues with long-term disability. There's some issues with something that lays us up for long periods of time that maybe we aren't able to properly manage our operations, and we need to take into account a contingency plan for disability, disease, divorce. I don't think many people, if any, really get into marriage expecting or wanting a divorce. I think that would defeat the purpose of the marriage. to begin with, but it's a reality of life. And when we're treating our ag operations, our cattle operations as a business, we need to, try and protect against divorce as best we can. And disagreement and disengagement. If we are partners with other people in our business venture, what happens when we disagree? What happens if one of them, say you're partners with somebody in a business, in your cattle feeding operation, and one of the partners becomes disengaged. They become disinterested and decide to not pull their weight anymore. Well, what happens in that situation? How can we manage around that type of risk? Um, and then we've got disaster and death. I'm sorry, my first slide, I should have said debt. Now I'm recognizing that, but we'll go with number 5 here: disaster and death. Again, what we had kind of hit on before: what happens if somebody passes away? But that number 1 risk, it should be debt. And by that, the 5D is bankruptcy. Are we protecting our personal assets in a way that they won't be impacted if things go sideways with our farming operation, with our cattle operation, so that it ends up, ending up in some kind of a bankruptcy or liquidation event? How are we going to protect our personal assets and the rest of our family? There's a tool that I use frequently, and I hope you can see this. I won't spend a lot of time on it, but I have this risk assessment worksheet, right? And so basically it's taking a look at those 5 Ds and saying, what's our current management plan? Are those risks currently addressed? And then we look at what is the probability of that risk happening. Death might be a less of a probability when you're 32 years old and have a young family and are in good health. It's still a potential, but the probability is lower than if you're in your 80s and have some underlying health conditions. So we just need to evaluate where we're at today, what would happen, the impact of that risk on our current plan. And then finally, my last column, I always look at, all right, what steps are we going to take to help to manage around that risk? And so that's a tool that we can use to help break down, some of the 5 Ds. And when I look at risks, there's more than just these 5 Ds out there for any kind of an ag operation. And one of the helpful tools that we can use is breaking our risk factors into different components. The known knowns, things we're aware of and we understand. A lot of that is stuff. For instance, we understand that storms happen and we might want to get property coverage or crop insurance, or we know markets are volatile. We might want to look at some pricing management insurance, things like that. Then you have your known unknowns. We know that they exist, but we don't understand them. By that I mean, like, maybe some weather events. We can't really forecast when they may or may not happen. Some health events, things like that. Unknown knowns, we do understand, but we're not aware of. And then finally, we wrap it up with unknown unknowns, and those are the freak events that could be a geopolitical nuclear war. We don't know if that's going to happen, nor do we understand why or the impact of what's going to happen there. So again, it's just another one of those tools that we can try and find and isolate some risks, so then we can look at building out a potential management plan, for those risks. And then, I kind of wanted to wrap it up with identifying just a few more of the other common risks that we see in ag business in general. One is land issues, specifically around farm transitions, specifically around inheritance. There might be a partition that has to happen because a couple of kids inherited land as tenants in common. and they don't agree on one wants to sell, one doesn't, well, we might need to partition that, which is a costly issue. That's a judicial remedy that is not a fun thing to go through. So how can we think about that and manage accordingly? Lawsuits, it's kind of common knowledge that we're a fairly litigious society these days, and lawsuits are common. So how can we protect some assets? How can we shield some liability, to prevent those lawsuits from derailing our operation? Employees, it's maybe not comfortable to see that they're a risk up there, but when we're talking about, cattle operations, and we're talking about, if an employee is running some equipment or becomes injured, or maybe they do something on social media and that doesn't align with what we want to see, right? So there's some risks there. How are we going to utilize some entities or some other legal tools to kind of shield risk from that employees bring? Taxes, where this is not a financial webinar this evening, but taxes as it relates to capital gains, inheritance taxes, estate taxes, things of that nature, gift taxing, capital gains, are all considerations as it relates to using entities for transition. Then the other kind of idea of taxes is we have specific income tax rules for specific legal entities, and they're not all equal. And so we just want to be aware of taxes when we're looking at setting up some of these potential solutions. And then transferability. I have used a fair amount of legal entities aside from trusts to transfer assets to the next generation or to somebody while we're still alive as part of an overall farm transition scenario. A common example, or I shouldn't say common, but a recent example, I have a farmer who he's in his early 60s, and over the next 10 years will be transitioning the entire the operations entity, which is an LLC, over to his son. And we're doing that through a combination of gifting some units of the LLC. We're doing it through some purchases from the son. He will be buying into the LLC, and all of this happens over a 10-year vesting schedule. And so, not to get too into the weeds, but they're a great tool to be used for transferring assets, but not every entity transfers the same way. And so it's just something to account for. All right, so we've got the depressing stuff out of the way. We talked about all of these, risks or potential risks. So what are some easy solutions, some simple solutions that we can maybe manage some of these risks? Well, in the one column, we have insurance, which I would imagine we're pretty much all aware of. I'm not an insurance agent. I have no affiliation. But I want to put it up there because even if you have proper legal entities in place, even if we have all of the corporate shield is protecting our assets, insurance is still important. And so we can look at liability insurance for accidents, things that might happen. Obviously property coverage, we want to cover our assets. One of the things that I've run into through some farms I've dealt with over the last year or so is because of the incredible inflationary cycle we are in, and specifically equipment and sheds and the replacement value of various farm buildings, we are seeing a lot of underinsured people right now, and basically just from a dollar perspective. And so something to look at is understanding what is the replacement cost of this cattle shed or machine shed or bins, or our equipment, and do I have the proper limits in place for my property coverage, pricing coverage, as far as commodity pricing. I believe last week you went into depth on market pricing and LRPs, stuff that I do not know nearly enough about. And so, but I know it exists. I know that the products are out there to help with that. And then life insurance, something that we often use as part of an estate transition plan, but also, can be used just as part of your general entity plan in order to, buy out a partner if something were to happen. And we use it often in a buy-sell agreement, which we'll get to in a little bit. So insurance is important to have. This is not an insurance webinar, but wanted to highlight that legal entities do not take the place of having good insurance. And so what are some of the common legal entities that we see, and how might they work? Basically, general partnerships are something that exist even if we don't have a written partnership agreement in place sometimes. And so they're this little bit of a gray area. Basically, a general partnership is when two different people, two different entities are coming together, and we are going to be pursuing some endeavor together, but we are maintaining our individual tax ID numbers. We are maintaining an individual status from a liability standpoint. And so general partnerships are fairly common that we see with farming entities, whether it's a couple brothers farming together or neighbors who might share some equipment, things of that nature. However, I would point out general partnerships really do not offer any liability protection. So as far as the managing risk standpoint, they're a little bit ineffective at that. We can look at limited partnerships. We have LPs, LLLPs, which is a limited liability limited partnership. And so act like a general partnership, but now we're shielding some liability. And those, we're looking at actually having a written partnership agreement in place, things of that nature. Limited liability companies, that's probably the most common that I deal with, especially if we're setting up new legal entities. They're very flexible. They are recognized, at the state level, but they've become quite popular for various different reasons. And then finally, wrapping out kind of our list of the common legal entities that we see are corporations. Corporations used to be, my understanding is, quite popular back in the 60s, 70s, in that vintage, because limited liability companies didn't exist. LLCs weren't a thing back then, and lenders were only going to borrow money to a corporation that owned the land, and weren't interested in cross collateralization, things of that nature. And so corporations were more common, still exist, we still use them, but they're a little bit less because of some of the taxation issues and some of the asset transferability issues that we see with corporations. So a little side by side for these, just so that we can kind of understand a little bit more. I've broken them down into what many farmers are utilizing as a sole proprietorship, right? Single owner. It's the easiest to form because you don't have to do anything. And then you go to a limited liability company, and that's where we can have one or more members, owners of the LLC. Still, again, fairly easy, fairly cheap to form. Partnerships, whether it's a general partnership or a limited partnership. So, we've got our categories here: sole proprietorship, LLCs, partnerships, corporations. Formation wise, corporations have shareholders versus members of an LLC. Corporations are a little bit more complex to set up. But what we're looking at here is this third row of liability. And what we mean by liability is are your personal assets? Is your person shielded from something that the business does? And so when we look at a sole proprietorship, there is no shielding. We have unlimited personal liability for what happens with those, kind of the 5 Ds with the actual business of the farm. Limited liability companies do limit the liability. It's not 100% limited. It's not 100% shielded. There are things like fraud that can what they call pierce the corporate veil. Partnerships. This is where it depends on the type of partnership. A general partnership, you have unlimited personal liability, just as if you were a sole proprietor. If you have a limited partnership or a limited liability partnership, you have a little bit more protections in that vein. And then corporations then shield their shareholders from liability, at the kind of the biggest level. Management control, the different various ways that these entities are set up. Tax treatment is something, I think probably a lot of us are familiar with, but basically your sole proprietorship, you're taxed at the personal level. Your LLCs, you most of the time would have it taxed to you personally, but you can elect on an LLC, you can elect to have it taxed as an S corp. Pass through taxation on general partnerships and limited partnerships, and then I think we're probably familiar with, but the corporations are what have what's called the double taxation, and that means that the income is taxed once at the corporate level and then taxed again to you as a shareholder when you receive those dividends. And so a few other things with these entities to compare with, but we won't get into all of those. I really wanted to look at some of these reasons for having the shield of the entity for for mitigating risk, which is what we're talking about. But I can send you this kind of side-by-side graphic later on. And so I would head back to, okay, now we have an understanding of kind of some of the tools, the entities that we could potentially use. And so if I'm going to sit down and I'm looking at my cattle operation and I want to set up an entity to shield some of the liability issues, I want to set up an entity to potentially bring on a partner, but also have things kind of written and in a good agreement together. So what are some of these considerations? How do we go about it? How do we set up an entity in order to have that? Well, first you have to file either articles of organization or articles of incorporation with your Secretary of State. And I think majority of you, maybe all of you are in Minnesota. An operating agreement or bylaws. So what are those? An operating agreement is for an LLC, and the operating agreement is the governing document. It says who's responsible for what within the LLC. It explains how distributions are made. It explains who gets to vote, who gets to manage the entity. All of those considerations are in the operating agreement. And I often get asked, if you're setting up a single member LLC, which would be, it's an LLC that I wholly own as an individual, do I still need an operating agreement? And I say yes. I still want to put in a boilerplate, kind of a simple basic operating agreement for the purpose of if transferring the asset down the road, we need some guidance for the purpose of establishing that we're being taxed the way we want to be taxed. And then also for the purpose of potential expansion, and we might bring on more members, whether it's children in a transition, something like that. We still want to get that operating agreement in place. Bylaws, basically the same thing, only therefore a corporation instead of an LLC. Again, it's the governing document. It's the one that explains how the legal entity will be managed. And so the next kind of step to, once you set up the entity, you've got your operating agreement in place, What happens in the event of a divorce? Well, we can set up what's called a buy-sell agreement, which basically it explains what happens in the event of any of these triggering events. And so it could be somebody wants to leave the company, wants to leave the entity. What happens to those units or shares? It could be if we get divorced, if any member gets divorced, who gets the cattle operation? And we can kind of dictate where those go. If a member retires, if a member passes away, we can outline what happens to their units in the event of one of those things happening. So it's a very important document when we set up an entity that specifically if it has multiple members, that it is clearly outlines all of these different risk factors that are inherent with business, inherent with livestock production, and we can set up a buy-sell agreement that kind of protects the what ifs that occur. A couple of things to consider with your entity. It's not just set it up and forget it. You need to have file an annual report with your Secretary of State. And then the new one that made the list this year is this FinCEN BOIR. What is that? Well, the federal government said we want to try to cut down on shell companies, money laundering, things of that nature. So we're going to set up this beneficial ownership information report, which is what BOIR stands for. And so if you have an entity that is registered with the Secretary of State, you need to file in 2024 a BOIR, which explains who is the who are the beneficial owners, so the main owners of the company, or who controls the company. So if I have an LLC for my cattle operation, but I'm kind of the behind the scenes, I'm the owner, but I have a manager who makes the day-to-day decisions, who makes the financial decisions for it. That person also needs to be put on this beneficial ownership report, and that gets filed with the federal government with FinCEN. And again, that is new for 2024. And it is something that all existing entities need to do by the end of the year. And any new entities that get established in 2024, you have 90 days in which you need to file this report. So it is important. And the other thing I will stress with this new requirement is the penalties are steep if we don't follow and they, for whatever reason, decide that you're trying to play some funny business with them. I believe it's like $500 a day fine, up to $10,000, and up to a year in prison for not complying with this FinCEN BOIR. So it's got some teeth to it. So something to consider if and when you do establish, or if you already have an entity. Other things to consider in order to maintain that shield, that corporate the corporate shield that protects you as an individual, protects your individual assets, your off-farm investments, things of that nature, is that we need to treat our entities as a standalone entity. And by that, I mean, it needs to look and feel like we're running this LLC as its own business, because when we start commingling funds with our personal funds, if we're not having annual meetings, if we're not having good record keeping for our entities, what can end up happening is a court, if you're in litigation, a court can come in and say, yes, you have this LLC in place, but you've been treating it kind of like your own personal account. So now you are personally liable for anything that happens within this LLC. And so it's just important that we don't just establish the LLC and think that we're hands off, that we're protected from these different risks that we're seeing. We need to treat it as a standalone. Part of that is separate accounts separate books, just maintaining that separation between personal and business, titling assets in the entity name. So for instance, if I have a semi and I've got a truck that's going to be hauling grain, cattle, whatever it might be, and it's still registered in my personal name. I never bothered to put it into the LLC. That thing gets in an accident. Yes, my insurance kicks in. Next goes after my personal assets because my LLC did nothing, because the LLC did not own the truck, right? So one of those things that we want to look at when we're talking entities is making sure that we're titling the assets in the entity name. And then the next thing is contracts. Frequently see contracts made out to, Joe Farmer individual is going to contract for the feeding of these cattle, or is going to enter into this lease agreement on a piece of property, on a pasture or something as, Joe Farmer. Well, that LLC or the corporation or whatever your entity is that is supposed to be protecting you is doing nothing because they're not a party to the contract, right? You individually are a party to the contract. And so you can make the argument that, oh, well, I meant it to go through the operating entity, but I didn't. Well, that's a weak argument, specifically when you could have just contracted through, the actual entity. And so another thing to kind of make the entity really stand alone as its own business. And so what are some of these other, non-entity type legal tools that I hinted at before? And again, we were just talking about contracts. So that is one way that we can protect from risk. And we have this idea in agriculture oftentimes that handshakes is as good as I'm good for my word. Handshake's all I need. And how many handshake agreements are out there? Well, you might have an oral contract in place, but let's reduce it to writing. And there's really 5 things that you need to form a binding contract. Mental capacity, which just means you're aware of what you're doing. Agreement on the purpose. I can't be thinking that I'm selling you a piece of property and you're thinking that you're buying a bull from me. We need an offer, an acceptance, and consideration. Well, consideration is something that that does get challenged occasionally. And with consideration, we're talking, is this a one-sided agreement that is more of a promise, or is there actually a benefit and a detriment to both people, right? So there has to be a give and take to both parties in order for it to be a good contract. Another thing that isn't an entity, but it's a legal tool that we can use, put it in a lot when it comes to farmland, when it comes to trying to gain access to ground, or also through a transfer of farm property is an option to buy. And what that is, it means that you don't have the obligation, but you have the option to purchase whatever the object or the property is. Oftentimes you'll see a lease agreement on some farmland that has an option to purchase in it, which just means that whatever the terms of the option are, that's binding. So we can kind of protect our the ability to not have grounds taken away from us through an option. Another thing similar to that but different is a ROFR, and that stands for a right of first refusal. And what that is it's saying that, so a classic example is I have a lease on some pasture, and within that lease, it says that I as the farmer, as the tenant, has the right of first refusal to purchase this property if and when it ever gets sold, or for a specific duration, something like that. And so what a ROFR does is basically it eliminates the ability for the landowner to just pull the rug out from under you, not tell you that he's going to buy the land, or he's going to sell the land, excuse me, and then he goes off and does that. So the ROFR protects you. You have to say no before he can then sell that property to whatever his third party is. And then again, I talked about it before, but asset titling, in terms of real property, in terms of land, things like that, we want to make sure that we understand how our land is titled, specifically as it relates to an estate plan, succession planning, whether it's joint tenants with rights of survivorship, tenants in common, our common ways that things are titled, but making sure that those assets that we want in the entity are titled in the entity itself in order to protect us from some of that personal liability. So an example, I don't know if you may or may not follow me on Twitter, I guess now X, but I came across this article last summer, which is a good, I guess not good, an interesting example of confirming verbal agreements in writing. And so the gist is that, and this was in Canada, but it's similar legal structure in Canada. But the gist is that there was a contract dispute. The price of flax that the farmer sold on I guess a somewhat of a contract went from $17 a bushel to $41 a bushel. And he was trying to argue that he gave a thumbs up when the elevator sent him a picture of the contract. And that didn't necessarily mean that he agreed to all the terms of the contract. It didn't mean that he signed it, but the court said, nope, a thumbs up is as good as writing. It's as good as a signature. And so now you owe $82,000 to the grain buyer. So it's just an example that, let's get our verbal agreements in writing. And when we do, let's honor our contracts and, just something that to be considered going forward. So we've talked about shielding some liability. We've talked about, some of these risks that we're mitigating. One of the big risks in agriculture, as I see it, because I work with it on a daily basis, really is this risk of taking a farming entity, a farm operation to the next generation and then the following generation. And so how can we use some entities for the transitions, right? So it's more than just the shielding of the liability risk, things of that nature. And so we can use LLCs, we can use corporations, something that we haven't talked about up till now because of it doesn't really shield us from liability is using a trust in order to pass down the assets and then using leases in place. And again, we talked a little bit about the buy-sell agreements, use those often for managing some of the risk within the business entity itself. But it's also a way that we can provide to pass on the owner's business interest when they pass away or when they retire. And so part of a transition plan, we can use these buy-sell agreements with an LLC or a corporation, something like that, in order to pass assets down to the next generation. Now, I have an example here. So this is a common structure of using some entities that I see as it relates to both, operating your farm entity through an LLC, but also how can we use it to transition the land. And so you see up here, we have dad and mom. They own their home acreage. They got 4 acres in the home right there. And that's just titled in their name individually. No big deal. Maybe that goes through a trust down the road. But that's not our big concern here. Our big concern is that we have one on-farm kid who's back and farming with mom and dad. And we have 2 off-farm kids. And, we want to be able to treat them equitably. Notice I didn't say equally, but equitably. And so what we end up doing is we set up this operating LLC down here on the left-hand side. And what that operating LLC does is it owns all the equipment. It owns all the cattle. It owns all the crops that are growing in the ground. It owns all the leases that we have. It owns everything needed to operate the farm except for the land. And so that operating LLC is owned partially by the on-farm kid. I mentioned earlier about, this 10-year vesting schedule that we're putting together. You know, so he might own a small percentage of the operating LLC, and then every year that increases as dad and mom sell him, you know, more of the operating LLC. The off-farm kids do not have any ownership in the operating LLC. The off-farm kids have some type of interest in the landholding LLC. Um, and so this kind of line that I'm drawing here between the operating LLC and the landholding LLC, this is protecting all of the people up here from any liability. So it's shielding liability from going up, but it's also a means of transferring these assets upon dad and mom's retirement and this whole entire transition. And so the operating LLC is owning the machinery, the crops, the livestock, all the tools, all the leases, things like that. And the land LLC is owning the farmland and the pasture, and that's it. And so what happens is the operating LLC leases from the landholding LLC, you know, the farmland. And so in the event of dad and mom passing away, there might be something within the buy-sell agreement that says this landholding LLC, you know, has to lease to the operating LLC for the next 10 years, at which time on-farm kid has an option to purchase the land at 85% of appraised value or something like that. Also could be done through a trust. But that's kind of the gist. It's a common way to structure a farming entity that isn't too burdensome, because we don't want to over govern what we're trying to accomplish. But we're also looking at shielding liability and also a means of transitioning ownership to the next generation. Okay, so we hit on a lot of different areas here, but what we just want to sum it up here with is, you know, how can we manage, you know, some of these risks through an entity? Now we're not going to be able to eliminate all risks, but your first step we're looking at is what risks are we trying to what risks are we trying to mitigate here? And using your advisors, using your attorney or your insurance agent, things of that nature, people like that, to help identify what are the potential risks out there. Comparing those entities, you know, there's pros and cons to every entity. You know, some, you know, have some tax implications, some have some governance issues, some are a little bit more costly to set up. Some might have some transition issues, or not issues, but just different considerations. So we need to compare those entities and see what's the right fit for us. And then we need to establish it properly, make sure you know, it's filed correctly, make sure that we have all the agreements in place properly so that we're actually shielding the liability like we think that we're doing. And then the ongoing management of that entity, again, we want to make sure that it is standalone so that if anything were to happen, if that lawsuit comes and you're looking at $2 million wrongful death suit, you know, we want to make sure that that thing is bulletproof, that is shown that it is its own entity, and we're not putting our own personal assets at risk. And then lastly, you know, let's just memorialize all these agreements in writing, and make sure that everybody's on the same page, and we have good solid agreements that are kept up to date, and you know, that is going to help to maintain some of that risk avoidance that we're looking for when we're using legal entities as it relates to agriculture. So that is my presentation this evening, and I'd be happy to answer some questions and see if anybody has any questions. Otherwise, we can just sit here and stare at each other, or you know, do whatever you'd like to do.
So I do have a couple questions, Clint. The first question is, how many years do you have once you sell in a good deal or turn over a farm to a family before outside people such as the government or a nursing home get involved, in Minnesota specifically?
Well, I cannot speak to Minnesota specifically, but I think what you're asking is Medicaid look back period, which
So.
oftentimes will transfer assets in order to protect you know, the older generation from having to sell assets because of nursing home obligations. And so that is a 5-year look back period, which means that if I transfer my assets into, say, an irrevocable trust, which means that I do not control the assets anymore, they have its own legal identity, then there's 5 years before I'm considered to not own those assets anymore. And then I would qualify for 100% Medicaid. My belief is that even if we go into the nursing home at, say, year 4, they take that into consideration that the assets were transferred 4 years ago, and that they take a percentage of kind of what was the value of those assets that I transitioned over or transferred over, effectively sold, or to the next kid. But the quick answer is there's a 5-year look back period for Medicaid issues.
The next question, is that FinCEN BOIR, excuse me, sorry, mandatory in all states?
Yes, yep, that is a federal requirement. Yep, and so some states, so in South Dakota, we have an option when we file our annual report. We have the option to list who are the owners. I don't know why you would. There's really no benefit that I see of that. But even if it's mandatory at the state level to file your beneficial ownership report at the state level, you also have to file with FinCEN. It is a federal requirement, and it applies to any entity that is that is established by being filed with the Secretary of State. So like general partnerships wouldn't count because there's no filing requirement for that. Some trusts, specific trusts, do qualify, but really we're looking at LLCs and we're looking at corporations that have filed with the Secretary of State that are required to then file with the federal government, the BOIR.
Does that still apply to single member LLCs? Probably mostly because you talk about how there could be someone different who's actually running the day-to-day.
Yep. Okay. There's no carve out for ag. There's no carve out for small business. There are 23 exemptions, and they're mainly it's other types of businesses that regularly report to the federal government. So like banks are exempt, accounting firms are exempt, things like that. But generally speaking, your run-of-the-mill land or operating entity, you're going to have to file with the federal government on that. And it doesn't matter how little business you do in it. If it's registered and in good standing with the state, we need to file it with the federal government.
All right. Had a question come in about the corporate veil. So the first part of that is, does it just take once piercing that veil to break it forever?
Not necessarily. So basically when we say that we're piercing the corporate veil, it's because whatever the specific facts are that led up to the issue that happened, that pertain to the specific case, would point to it not being treated as a separate standalone entity. If another incident were to occur down the road and we can prove that, say this corporate veil was pierced, and we've taken remedial steps, we're now having our separate books, we're really treating this thing as a standalone entity. It's going to be fact specific for each incident. And so now, the next time something happens, it's not necessarily going to say, well, you pierced it before and you're forever unclean. That's not the case. So,
All right. Kind of a follow-up to that came in. What about the other direction? So we talk about using the LLC or that account for personal use, but what about using personal funds for the LLC? Is that just as bad?
No, because so say for instance, you're the sole member, or you and your brother, or you and your spouse. Say there's two members. It doesn't really matter. One thing that I would recommend if you're going to, because what I'm saying is you need to have cash within the LLC in order to operate. And so what that would be viewed as is, I'm taking my personal money and I'm going to put it into the LLC checking account. That is now a capital contribution. And so if I'm the sole member, no big deal, because I own all of the units or all of the ownership interest of the LLC. If there are multiple members and only one person is contributing the cash, it would either be viewed as a loan, and then we're not messing with the ownership interest, or B, it would be viewed as a capital contribution, which then we might have to reallocate the interest, the ownership interest of the entity. Oftentimes we'll see individuals loan money to LLCs, and then if we do that, we want to make sure it's documented in just a nice one-page promissory note, and there is a federal IRS a minimum interest rate that you must charge if you do that. So something to consider in order to really maintain compliance. You'd want to document that loan to the company, or it's viewed as a capital contribution.
Okay, so the other question that came in is, and I'm gonna let you get on your soapbox on this. What level of complication of an operation do you see it as an attorney really needs to be involved? And kind of in addition to that, what's the value that you provide as an attorney in the situation when we're setting up these business entities? Because I feel like some of them are quite simple, but some of them get complex pretty quickly.
Sure, yeah. And that's a good question, right? I mean, it's a similar, I see a similar thing in the estate world where there's LegalZoom, there's a lot of these, you can just find forms on the internet. Couple things that to consider is that we want to have state specific rules, because these entities are registered at the state level. And so we need to know what the local jurisdiction is, which a lot of the national, the forms that you find online may or may not be appropriate for that state. But as far as setting up the entity itself, the actual filing, the actual making the entity exist with the Secretary of State is very simple, very easy. Most states have an online where you just fill out a form, you pay them $150, boom, you have your LLC. That's not the hard part, or that's not where we necessarily need the attorney's involvement. Where we want to see the attorney's involvement is specifically if there's multiple members, but even if it's a single member LLC, is the operating agreement. And I kind of hit on the operating agreement before, but that is really the governing document. That's the one that explains how this entity ought to be managed. And so with that comes a lot of considerations as it relates to the buy-sell agreement, as it relates to, various different compliance issues. And so that is the place where I would spend a few dollars and sit with a good business attorney to understand, what are the risks that we see. Because one of the benefits, I call it a benefit of being an attorney, is that I get to see a lot of different scenarios come across the desk, things that oftentimes the farmer might not think of, either good or bad. Oh, I didn't even know that was an option, or oh shoot, I didn't know that could happen to me. And so there is no rule of thumb as far as how complex an entity needs to be in order to seek legal advice. But I will say that generally speaking, it doesn't take a lot of dollars to set something up properly. I mean, say you're going to spend $1,000 to set up an entity, with your partnership on your operating entity, because you're going to transition this thing down to the next generation. Well, that's $1,000 now. That's going to save a lot of thousands of dollars come probate time, or come, an issue down the road. And so it's always important to look at, no, we don't want to be spending 25, 30 grand to set up a simple LLC. That's a highway robbery. but we want to be saying, let's spend a little bit now to avoid, a heavy payout down the road. And that's just a balancing act of risk. But didn't really answer your question because there's not a clean cut, how complex does it need to be? But it's each to their own, but generally speaking, and we're talking Minnesota, I'm over here on the far eastern side of South Dakota. We're not the high dollar New York City attorneys charging $1,500 an hour, right? So it's not unreasonable, to pay for an operating agreement.
Sounds good. Sorry, excuse me. We had a couple more come in. One is, do you have an example of what capital contribution documentation should look like, especially for small business, very small
Sure.
LLCs? And I maybe it's time to plug Braintrust.
Yeah, I mean that's one, as far as a document, it's very simple. And usually, like when I set up an operating entity, so for instance, I'm using LLC because they're the most common. When I set up an operating agreement for an LLC, with the operating agreement, I just have a one-page form that's blank that we fill out when a capital contribution happens. And so at that point in time, then so say I'm going to contribute 100 grand or $1,000 or whatever it is to the entity. We just fill in on this date, like a member contributed this much in exchange for the reallocation of the ownership interest. If it's a single member, then it's just basically then you're just following what is your capital account as it relates to an accounting standpoint, because there is no interest that needs to be shifted around. So it's a very simple one-page document that I include with all my operating agreements. There's that, and then there's also a way to incorporate to bring in new members into an LLC that's called a joinder agreement, and I just send a form copy of that along with my operating agreement too. And so if they join, we bring in a new member and they pay $1,000 to become a member of my LLC. They fill out this simple form, and it's not overly complicated. It doesn't need to be overly complicated, and that's the beauty of the LLC.
All right, there's more coming in, Clint. So hopefully you got some time.
Yeah.
What's the best way to knowing that you're not an expert on taxes, but the best way in this context to minimize inheritance tax? And I think the goal is not having to see the kids have to sell pieces of the farm to pay that tax.
Sure. Well, right now, and I'm at a disadvantage because I don't know if Minnesota has a state inheritance tax, and if they do, what the amount is. But from a federal level, we have an exemption amount right now of, I think it's 13.6 million per individual. And so that would be 27 million for a married couple. And what that means is that all the value of the estate when you pass away, if any value above that, then it gets taxed at 40%. Now that exemption amount is going to sunset at the end of next year, at the end of 2025. And so that is most likely going to revert back to $7 million per individual, which is a significant cut. So if we're dealing with an estate that is much less than that amount, really inheritance taxes aren't a big issue. Then we would look at the state inheritance tax and see, does it make sense to do some kind of a gifting strategy while you're alive into some type of an irrevocable trust, that we're using up some of our gift tax exemption there, so that we don't have that implication at death. But again, from a federal level, if your estate is larger than that, that current $27 million, or even as an individual, if your estate, your taxable estate amount is going to be higher than that limitation, it's time to sit down with a good CPA, a good attorney, and really understand how we can utilize some of these special trusts, to get that carved down. But generally speaking, it hasn't been a large issue, but I foresee it being an issue if that exemption amount does get cut back more than half.
Right. One more that came in. Can you have members of an LLC be management and some members only receive yearly payments even though they have no management capabilities?
Yeah, and I will clarify. So LLCs are very flexible. You can have all sorts of different levels of rights and management duties and voting rights and things like that, unless you are trying to be taxed as an S corporation. If you are an LLC that elects to be taxed as an S corp, you can only have one level of common units. Assuming that's not the case, what oftentimes will happen is you'll have a Class A and a Class B type of units. Some call it preferred common units. And what happens is, our Class A, that's all the voting rights. That is the owner operator. They're making the decisions, and there are a few exceptions. Generally speaking, a liquidation event where it says, hey, we're going to sell all or substantially all of the assets that the LLC owns, we're going to need buy-in from the rest of the members. Or if we're going to go out and take on tons and tons and tons and tons of debt, whatever that threshold might look like, we're going to need the buy-in from, the approval of all the members. Other than that, the overall vast majority of the management decisions can be done by that whoever owns the Class A units. The Class B units can basically be economic rights only, right? So they have no control, they have no, voting interest. They are just merely a passive investor, you might call them. And now they're receiving, annual distributions or however frequently you're doing distributions. And the distributions don't necessarily need to all be the same either. So different classes of units can have preference or priority when as it relates to distribution. And that's when we get into a little bit more kind of sophisticated waterfall scenarios of who gets what amount. When we have $1 million to take out of the LLC, who gets paid first and how much, and then it just flows down the waterfall. But yeah, LLCs are very good for that flexible type control, voting versus non-voting ownership.
Okay, here's another one. If I had previously set up a single owner LLC and then got married, am I no longer considered a single owner LLC in the state's tax laws? Which you may or may not be able to answer.
Yeah, I don't know that as it relates to state tax laws. I do know that married couples can own property individually. And so you would still own that LLC as an individual. As it relates to taxation, sorry, I can't answer that.
I mean, that makes sense to me. I mean, you still, just because you got married, that LLC isn't automatically shared. So
yeah, but I will say, and something I didn't hit on as it relates to divorce is prenuptial agreements, and how they might, come into play. Because I will say you can own property as an individual even when you're married. However, some states, and every state is different as it relates to divorce laws. But I can speak to South Dakota, where they will really try and lump in everything into the overall valuation of the marital assets, and then try and distribute things equally as they can. That doesn't necessarily mean that you have to give away 50% of your LLC units, but it would say, we're going to value the LLC at $1 million. We better find $1 million somewhere else that the other spouse can get in the event of a split. So it does get a little bit, interesting and as it relates to divorce. But that's why I said, a prenuptial agreement, a premarital agreement can prevent that and can outline what happens in the event of a divorce. And those are not uncommon when we're talking about the size of assets that that we're dealing with in production ag right now.
thank you, Clint. That was great. I learned a lot.